So I have asked Judge Friedman to introduce our speaker because he knows him well, and I wanted to make sure that you all knew him well. Paul.
It's a very crowded podium here this morning. So I'm just delighted that Roberta asked me to introduce to all of you my friend and one of the newest judges in our federal courthouse here in Washington, D.C., D.C. Circuit Judge Srinivasan. You know, Judge Srinivasan was born in Chandigarh, India, and when he was 4 years old, he and his family moved to Lawrence, Kansas, where his father was a professor of mathematics and his mother taught at the Kansas City Art Institute. He was a basketball star at Lawrence High School. He still plays basketball. And despite his multiple degrees from Stanford, BA, JD, MBA, he is still the most loyal Kansas Jayhawks basketball fan you will ever meet. In fact, he presented one of the two judges for whom he clerked with a T-shirt stating in very bold letters, "Kansas basketball is life, the rest is details." After he graduated from Stanford with distinction, he clerked for that judge, J. Harvey Wilkinson, on the Fourth Circuit, and then for Justice Sandra Day O'Connor on the Supreme Court. And between his private practice years at O'Melveny and Myers, where he had an unusually expansive pro bono practice, and his public service at the Solicitor General's office, 2 of those years as the principal deputy Solicitor General, he argued 25 cases before the United States Supreme Court, and many, many cases before appellate courts around the country. On April 22nd, 2013, just a few days after his confirmation hearing before the Senate Judiciary Committee, I happened to be at the Supreme Court when he made what would be his last argument as an advocate before the court. And as he stepped to the podium, I noticed he had no books or papers with him. Yes, he spoke without any notes before the United States Supreme Court, both in presenting his main argument and in rebuttal. And I later asked Walter Dellinger, one of Shree's mentors, whether Shree had always done this, arguing before the Supreme Court or any court without any notes, something that I could not imagine ever doing. And according to Walter, Shree was actually embarrassed during his early arguments by his ability to do this so effortlessly. So he would take blank sheets of paper and he'd lay them on the podium so that he would at least appear to be mortal. Now, Shree lost that last argument 6-2. But a month before the court's decision came down, he had been confirmed by the United States Senate for a seat on the D.C. Circuit by a vote of 97-0. He became the 58th judge ever to sit on that court and the first Indian American ever to sit on any federal appeals court. And I suspect that his 97-0 win will stay with him much longer than the 6-2 loss. Since that day of his confirmation, of his swearing in, he's authored many published opinions, 4 concurring opinions, and no dissents. He's very collegial. And his opinions are clearly written, intellectually sound, nuanced in their reasoning, thoughtful, respectful, and civil. And I say this not just because he hasn't reversed me yet. That day will come. It does with all of my friends on that court. But I say it because it's true. The day of his investiture, one of his sisters, both of his sisters spoke actually, and one of them said that Shree had 3 clear priorities in his life. Family first, his professional responsibilities in the law second, and as I said before, the Kansas Jayhawks. And then his sister spoke of Shree's very first argument before the Supreme Court when he was a young lawyer. His newborn twins, Maya and Vikram, were just a few weeks old, and Shree put a sock from each of them in his suit pocket that day to give him strength, confidence, and luck. And his sister told us that for every argument since then, he's kept those baby socks of Maya and Vikram's in his pocket, quote, in case he ever wavered from who he really is, she said. On the day of his investiture, Sri pulled those 2 socks from his pocket and showed them to all of us assembled, presumably in the hope that he will never stray in his new role as an appellate judge from the civil, unpretentious, and centered person he is. So please join me in welcoming to the American Law Institute one of the newest members of the U.S. Court of Appeals for the D.C. Circuit, Judge Srinivasan.
Thank you so much, and thanks so much to Judge Friedman for that very flattering and kind introduction. Paul, I think as you mentioned, I've yet to author an opinion in which I and my colleagues are reviewing one of your decisions. In light of your exceedingly gracious introduction, though, when I'm next in the position of doing that, I think the odds of a vote by me in favor of affirmance may have just gone up by a little bit. Now, I know I'm new to ALI, and some of you who don't know may be wondering whether a relatively new judge like me would be so susceptible to flattery that it would actually leave me more inclined to vote for an affirmance, even if only by a little bit. And rest assured, I'm only joking. The odds of an affirmance actually went up by a lot, not just a little bit. As a newcomer to ALI, I'm really honored to have been asked by Roberta and the Institute to give remarks to this august group of lawyers at the outset of the annual meeting. Many thanks for inviting me to begin my time as an ALI member by addressing the membership. I was nominated by ALI for membership several months ago, towards the end of last year. When the Institute reached out to me to ask about my interest in joining, I knew that ALI members represent the very best of all walks of the profession. So I immediately set out to ascertain just how exclusive a club I was joining by doing what any of us would do nowadays. I plugged ALI into a search engine to find out what I could about the Institute. What I discovered right away in the first series of returns from the search query is that ALI, somewhat immodestly, I must say, refers to itself as the greatest and used to be named Cassius Clay. But once I moved past the entries for Muhammad Ali or Muhammad ALI in this audience and made it to the entries for the American Law Institute and read about the correct ALI, I couldn't help but ask myself, what had I done to merit being asked to become a member? I wondered, was one of my early opinions so pregnant with pearls of wisdom and brilliance, and had it gained such acclaim and admiration in the profession that ALI now felt compelled to invite me to join the membership? Admittedly, which opinion I'd written that might fit that description wasn't immediately apparent to me. But in reviewing my opinions, I quickly found the answer. And this is true. In September of last year, our court issued an opinion in which I was the authoring judge in a case called In Re APA Assessment Fee Litigation. And APA in this context is not the Administrative Procedure Act, it's the American Psychological Association. I'm sure a great many of you would have read that opinion a number of times. But in case you haven't, the citation is 766 F 3rd 39. The opinion contains trenchant analysis like the following, which is the first real sentence of the opinion following a short introduction. And just to do it justice, I'm going to quote directly from it. Quote, "This case is before us on a motion to dismiss, so we accept the facts as alleged in the complaint," close quote. That is quite obviously ALI-worthy panache. Now, I won't bore all of you with the details of the various issues we considered, but I saw pretty quickly why that opinion was one that quite likely sparked ALI's interest in me as a member. The case was a diversity case, and the first issue was whether the plaintiff's unjust enrichment claim could go forward past dismissal, even though there was a contract between the parties that had addressed a lot of the issues that were bound up in the unjust enrichment claim. At the outset of the opinion's discussion of that issue, I came upon the first sentence of what might well have garnered my attention to ALI, and that sentence read as follows. Quote, "As summarized by the restatement, a valid contract defines the obligations of the parties to matters within its scope." That sentence was quoting the restatement third of restitution and unjust enrichment. I think you see where I'm going with this. My opinion for the court cited the restatement of restitution some 9 times and relied on it very heavily. And then, if that weren't enough, in a separate section of the opinion addressing an entirely distinct issue, the opinion cited the restatement second of conflict of laws another 8 times. Basically, I'd written a pitch for ALI membership. Of course, the implication I'm drawing here may seem rather absurd, and many of you may understandably be thinking that. ALI would never crassly consider someone for membership as a kind of reward for mentioning ALI materials in the course of an opinion. But before you assume the absurdity of that tit-for-tat arrangement, let me just tell you one more fact before I move on to the meat of my remarks finally. And this fact is true, and I can verify it if anybody cares to see it. Our court's decision in that case was issued on September 5th of last year, a Friday. ALI first reached out to me to inquire about my interest in membership on September 8th, the following Monday, the next business day. Coincidence? I can only say that one has to marvel at the speed and efficiency of the membership team's responsiveness. It's really, truly arresting. Well, of course it was a coincidence, and not a terribly unsurprising one in my case. As an appellate advocate, I was always very partial to relying on the restatements, the model codes, and along with any widely respected treatise, because I understood the esteem with which they are held by judges. And now that I'm a judge, my law clerks would confirm that I'm very keen to make sure I know of any relevant restatement, model code, or treatise commentary and discussion when examining the cases that now appear before me. The case in which I wrote the decision that I was just talking about was at the end of my first term on the court, and now I'm nearing the end of my second term. So I've only recently made the transition from appellate advocate to appellate judge. I thought I'd use this occasion to share a few reflections on that transition, on a bit of what I've learned at the outset of my time on the bench, and on one matter in particular, and that is the process of collective decision-making as a court. And I thought I'd also touch a little bit on what implications that process might have for effective advocacy before our court and other courts, some subject in which some of you may be interested, having now experienced things from behind the bench rather than at the podium in front of it. An important initial point about the transition from advocacy to judging on my part stems from the obvious distinction between advocacy on behalf of a client and impartial decision-making on behalf of a court. For very good reasons, our profession's ethics rules state that a lawyer's representation of a client does not amount to any personal endorsement of the client's views or actions. In my nomination and confirmation process, I was quite clearly the beneficiary of that fundamental principle, with senators from both parties saying in the course of my hearing, bearing allegiance to that fundamental tenet. Regrettably, as we know, that has not always been the case in the confirmation process, and the capacity to attribute a client's views or actions to a lawyer representing them has not been confined to any one political side. I only offer that I hope that my experience is very much the rule in the future, true to the fundamental tenets and best traditions of the profession. With that said, what have been the most interesting or challenging parts about the transition from appellate advocacy to appellate judging? An initial reaction is that appellate advocacy turns out, unsurprisingly, to be highly germane and useful experience. When briefing and arguing cases as an advocate, we of course aim for clarity of presentation, and that, unsurprisingly, is very much at a premium in the eyes of a judge. The briefs we advocates once wrote are now the ones we read as judges. The arguments we once made are now the ones we hear. The questions we once answered are now the ones we asked, and the decisions we once predicted are now the ones we render. But whereas as an advocate, one is duty-bound to be vigorously partial in service of a client's cause, as a judge, one is duty-bound to be rigorously impartial in service of the court's cause. As an advocate, we know which side we're supposed to support, but as a judge, the decision of which side to support is not, of course, is not made for us. It's something we have to determine for ourselves. What I'd like to touch on is a particular dimension of that decisional process, and that is that one not only has to gain comfort in making decisions, but one quickly appreciates that she or he, in fact, cannot make decisions, at least in a vacuum on one's own. It's necessarily the collective nature of the appellate decisions on which I'd like to focus, and in particular on an integral aspect of that process of collective decision-making. And that's the strong impetus towards achieving consensus whenever possible, something that many of the judges in the room, I think, can attest to firsthand. That dynamic, the urge to consensus, has been very important and illuminating in my experience, and I'm not at all alone among the judges who have recently made that transition to perceive that the degree of impetus towards consensus is more pronounced than perhaps we would have anticipated. It's also a highly fulfilling part of the job. I'm privileged to work with terrific colleagues on my court, as Paul knows well and as many of you know firsthand. In fact, I not too long ago applied for clerkships with several of my colleagues and very much hope to clerk for and learn from them. They displayed their very keen wisdom as judges by declining even to interview me, much less to hire me, with very good reason, I should add, a fact that I had a great deal of fun sharing with them when I first joined the court. Well, now I work very closely with those judges as colleagues, and I'll address 4 questions about the impetus among colleagues on the appellate bench to achieve consensus in decision-making. First, do we in fact try to achieve consensus? Second, if so, why? What's desirable about it? Third, how do we attempt to forge consensus? And fourth and finally, when in the decisional arc does the push for consensus come to the fore? First, do we in fact try to achieve consensus? It won't surprise you to hear that the answer is yes. But it doesn't necessarily need to be that way. Judges could operate essentially as individuals, with the consensus coming about when all the judges happen to disagree, but without any real work being done to bring about consensus when it otherwise might be elusive. But my experience, and that of many colleagues with whom I've discussed the issue, is that appellate judges place quite a high premium on achieving consensus. With particular respect to the court on which I now sit, Chief Justice Roberts, who of course once sat on the same court, has commented on the emphasis on our court of achieving consensus. As he put it, it's firmly embedded that we work real hard to be a court and not a collection of individuals. I don't want to overstate things. Of course, judges generally don't sacrifice firm views or core principles in order to achieve unanimity. And there certainly are situations in which a judge feels compelled to write separately, either in a dissenting opinion or perhaps a concurring one. As Paul mentioned, some of my first opinions, in fact, were separate writings. And the decision of when to write separately is one of the more interesting and delicate ones we face as an appellate judge. But while those occasions for going on one's own and writing an opinion certainly do arise, they come about in the face of a palpable push in favor of attaining unanimity. Based on my experience, I believe that if one took a blind poll of each judge's views of a case when going into conference, or at least when going into oral argument, one would find a good number of cases in which there would be disagreement at that point, but agreement at a later point when things get ironed out in conference. This is not a sacrifice of principle. It's instead a willing to learn from one's colleagues and on their part to learn from you. Second, why is there a consensus in favor of consensus? What's desirable about it? Well, there are several motivations. For one, a unanimous decision is more likely to command respect within the courts and also outside the courts. That respect, in turn, fuels stability in the law because a unanimous decision is less likely to be second-guessed by the en banc court or perhaps the Supreme Court, and more likely to be sustained in a subsequent case in the same court. And from the perspective of both courts and those outside the courts, unanimous decisions promote a particular kind of respect for the courts as an apolitical and impartial institution. Judges want to believe that we are acting apolitically and impartially. Additionally, there's an understandable sense that a decision with the support of all the judges is more likely to be correct. There's a sense of security and commonality and agreement. And as an institutional matter, and the reach for unanimity and even the effort to achieve it itself promotes collegiality and good relations among judges, which of course is wonderful for the institution. It's also, frankly, often human nature in a group dynamic to minimize disagreement and to want to build the trust and respect of one's colleagues. And in the end, I suppose every judge would just as soon avoid the task of penning a separate opinion if unnecessary to do so. There's no sense in making the judge's job any more difficult than it has to be. Third, how do we go about the process of moving towards and eventually attaining consensus? One obvious mathematical point here. It's much easier to achieve uniformity among a manageable number of individuals, such as the 3 persons who make up an appellate panel. This, of course, means that in most situations, there would at most be only one person who might initially be inclined to disagree with the majority preference, and hence only one person who would need to come around. And that person will confront immediate questions about whether it's more desirable to hold out and write separately, in which case she or he would relinquish much of the ability to shape the majority opinion, or to express openness to joining the majority, in which event she or he perhaps would retain some say over the contours of the majority disposition. In such situations, when there's uncertainty about consensus, what do judges do to attempt to achieve uniformity? One common tack is to narrow the scope of the decision, both in terms of the issues that are reached and the way in which those issues reached are resolved. There's often a range of choice in those matters. One important way in which to narrow the issues reached is via doctrines such as forfeiture or waiver, which may be a straightforward way to dispense with an issue on which there otherwise might be disagreement, and to leave in place issues on which there's common ground. More broadly, threshold non-merits considerations such as jurisdiction, standing, ripeness, and the like are ways that courts can sometimes achieve consensus in outcome where it might be more elusive to achieve if courts were to reach out to get to the merits. Now, precedent, of course, can form an important part of the discussion. If decisions of the court or another court, including the Supreme Court, touch on the issues in the case, the interpretation of that precedent can afford a basis for resolving an issue on which there may be an inclination to disagree. In all of these respects, judges unsurprisingly like to simplify the issues to make the decision easier, and ultimately to make the writing of the opinion easier. Finally, an overarching condition that facilitates achievement of consensus is open-mindedness on the part of judges and a healthy respect for the views of one's colleagues. My distinct impression and experience has been the judges are not unduly prone to viewing cases as open and shut matters, especially in the presence of a colleague who may have a different instinct about how a case should be resolved. Judges are open to being persuaded, which makes good sense given that our colleagues have had looked carefully at the very same issues we have and presumably have the same interest in getting things just right. And judges well understand that we're collectively employed in a long-term endeavor with long-term relationships. Open-mindedness towards one colleague's views presumably will in turn be met with open-mindedness by those colleagues towards your own views, now and in the future. I come now finally to when the discussions aimed to achieve consensus take place. At what points in the decisional process do those efforts come to the fore? Of course, they often begin in earnest when judges initially come to the conference to cast their votes. Occasionally, there may be discussions beforehand, but that's the exception, not the rule. In a court like ours, though, in which oral argument rather immediately precedes the conference, and is frequently the first time that judges will have occasions to learn one another's views about a case, the efforts to attain consensus can begin implicitly in the course of the argument itself through the judge's questioning of an advocate. Those efforts may also continue after voting in conference in the course of drafting an opinion. This brings me to the last set of considerations I wanted to touch on this morning, which is what lessons we might draw as advocates from the impetus on the part of appellate panels to achieve consensus when possible, and from the process by which we try to do so. I should issue an important cautionary note at the outset of this. A very prominent appellate advocate, one of the most admired appellate advocates any of us have ever ran across, and very justly so, said the following, and I'm quoting, quote, "Be particularly skeptical of advice on how to argue an appeal from appellate judges," close quote. That much admired advocate who gave that warning was named John G. Roberts, Jr. He said this before he himself became an appellate judge and ultimately Chief Justice. But that advice notwithstanding, I ordinarily bow to my superiors. I'll proceed to go ahead and give some concluding thoughts on the implications of collective decision-making for appellate advocacy. Much of this follows naturally from and is the flip side of what you've already heard. First, with regard to briefing. The goal, of course, is for your side to be in the conversation when judges try to achieve consensus. There may be cases in which one has no hope under the law, and there's little one can do to rectify that. But in those cases when one can potentially see a case going either direction, here are some considerations one might bear in mind. First, because judges look for ways to narrow the decision if necessary to achieve unanimity, or to fasten around a threshold question of the court's authority to rule on the matter, give careful consideration to issues like waiver and forfeiture, as well as threshold questions of jurisdiction and the like. That includes the raising and preservation of arguments in the appellate briefs themselves. We see many briefs that give attention to those kinds of issues and to good effect. Raise objections on those grounds when feasible, and insulate against those challenges on those grounds when you can. As we've discussed, precedent, of course, can play a very, very important role in the efforts to narrow the issues on which the court will pronounce. And it's, of course, highly important to know the court's precedents and to understand where the judges are coming from with respect to that. Additionally, the conversations about your case at conference often addresses questions of workability and feasibility and acceptability of a resolution in your favor. Conversely, the discussion might well concern the workability and practical feasibility of a decision in favor of your opponent. This has obvious implications for the presentation of arguments in a brief. Winning the workability-feasibility battle can go a long way to putting your side in the best position to have the discussion and ultimate consensus weigh down in your favor. This also points up a broader point. If the goal is to be in the conversation when judges are trying to achieve consensus, an associated goal is, of course, to avoid being out of the conversation. From that standpoint, if the logical implications of your position could conceivably be seen as unworkable or unpalatable, it may be time to rethink it. In that sense, it's sometimes most important to avoid losing a case than to win it, because avoidance of a loss can at least keep you in the conversation among the judges. And it's conceivable that their discussions about attaining consensus ultimately pull in your direction. Now, a word about oral argument. There's a constant question about whether oral argument matters. As a former advocate, I'd like to believe that it does. In light of the general open-mindedness of judges when first interacting about a case, I think oral argument can matter a great deal. Of course, not in all cases, and not with all judges in all cases, but in a good number of cases. Gaining the attention of even one judge with your argument can serve you well in the post-argument discussion at conference, given the interest of all judges in hearing out the views of any one of their colleagues, and the resulting possibility that the views of one judge will have a significant effect on the dynamic and direction of the discussion. Argument, as noted, is often the first time the judges get a sense of each other's views about a case. Be attuned to that dynamic. You have an opportunity to be a constructive part of that conversation, and an advocate can best advance his client's cause and best advance the possibility that the conversation on achieving consensus works in one's favor if they answer the judge's questions in a conversational and forthright manner without undue hyperbole or overstatement. This is stating the obvious, but the obvious point, the opposite side is also part of that conversation, and needless to say, it does you little benefit to personalize the dispute or cast unnecessary aspersions at the motives of one's opponents and things of that nature, although one would be surprised at how often we see things like that at oral argument. And it, of course, selfishly speaking, does little to act in any way other than completely, wholeheartedly respectful of all the judge's questions. We like to believe that our questions are particularly important, and it probably behooves you to join us in that, even if we're completely mistaken. Judges don't attempt to hide the ball at argument. We have every interest to lay bare our concerns, to assure that a preliminary assessment we might have is not off base, and also to make sure our colleagues hear our concerns and potentially find them to be well-founded. The judge's questions are genuine, and they should get an advocate's attention and best response. On our court and in many courts, conference ordinarily occurs fairly immediately after oral argument is done, and it's not at all uncommon for the judges at conference to discuss what just happened at oral argument, especially if there was a failure by an advocate to put to rest or respond to a key concern conveyed by one of the judges in questioning. Any non-response or evasion can make it very difficult to attain a consensus resolution in your favor at conference, because all the judges will have just heard the exchange and noticed the inability to address a central concern of one or more of them. It's especially important to address each judge's questions because the judges may be asking questions not only to attain an answer for themselves, but also because, as they're learning about engaging their colleagues' concerns for the first time, they may be channeling their colleagues and attempting to show that the colleagues' concerns either are very real or can be overstated or overcome even. So I think nobody knows better how colleagues may be reacting to a case than the judges themselves, so it's very, very important to pay attention to this dynamic. Throughout, it can be highly effective, I'll say, to earn credibility by acknowledging that your arguments are not invulnerable, but explain why you should prevail nonetheless. Judges credit such arguments in the post-argument discussion in conference. This reminds me of a recent argument where one side got up before our panel and explained that it would be extraordinary and unthinkable to rule in favor of the other side. And then the other side got up in argument and said it would be extraordinary and unthinkable to rule in favor of the first side. And we as judges are left thinking that neither side probably is particularly credible in making those kinds of assertions, and it behooves, I think, everyone to be a little more sober-minded in presentation. In terms of charting a narrow path to victory in the consensus debate at conference, it's important to have in mind what may potentially be a narrower path to victory for your side than your first-order position, and to be prepared to articulate it. It can be dangerous to rely on arguments that were not fleshed out in the briefing, of course, because the judges won't be familiar with it or expect it, and they may look skeptically on something that was little covered in the briefing. And finally, in furtherance of the important interest in putting forward a palatable and workable resolution, it can be precarious to favor logical purity over practical feasibility. An outcome that strikes the judges as unworkable or unpalatable in its implications for future cases is highly unlikely to bring about a consensus resolution in one's favor. One should give serious thought, I think, to giving up a little on purity in service of gaining a little on acceptability, at least for the purposes of putting your argument in the game and a discussion among the judges about achieving common ground. And it can be equally important to point out any significant challenges faced by the other side with respect to workability and acceptability, so that it can help to tilt an open-minded panel's efforts to reach common ground away from the opposing side and in your direction. None of this, of course, can transform an unwinnable case into a winnable one. We're only talking about cases in which there's a possibility of a favorable resolution. But hopefully, these thoughts from someone who has recently made the transition from advocate to judge are at least somewhat useful in considering how judges approach the task of deciding a case and what that might suggest is important to bear in mind in presenting a case to the judges. I thank you very much for the courtesy of your attention. I wish everybody the best with this week's meetings and the events, and I very much look forward to working with and perhaps meeting all of you in the course of future ALI initiatives. Thank you so much.
Well, Judge, you commented about what we're all about, which is collective decision-making as well. So it was really important not just to understand from the court's point of view, but from our institution's point of view. So the judges said he would take a couple of quick questions if anybody wants to ask. And if not, we'll say thank you very much, and we look forward to having you as a member of the Institute. And I will tell you, I thought it was very good of us to wait until Monday to call you instead of Friday. So it's an honor to have you, and thank you. And now we'll go back to foreign relations. Thank you, Judge.